Okay. Welcome. My name is Ron Brand. I'm director of our Center for International Legal Education. This is also a joint class between Professor Matianga Sirleaf's Public International Law class and my International Business Transactions class. But the special opportunity today to have some guests with us who have come up from Washington and going to share with us thoughts about a book they've recently published. I want to say something about the book. The book is the 6th volume in a series, the CILE Studies Series, Center for International Legal Education Studies Series, with Oxford University Press. We've got the first 5 volumes here if anybody wants to come look at them after the program. The book is General Principles of Law and International Due Process. I want to say first something to introduce the two authors of the book who are going to be speaking to us today, and then say a couple of things, comments about the book itself. Charles Kotuby is a 2001 graduate of the University of Pittsburgh School of Law. He also received an LLM degree from University of Durham in the UK. He did an internship at the Hague Conference on Private International Law. He's now a partner in the Washington, D.C. office of the Jones Day law firm, where his work is focused on international litigation and commercial and investment arbitration. He's appeared as counsel in international matters before the U.S. Supreme Court, the Court of Justice of the European Union, before ICSID, the International Center for Settlement of Investment Disputes, and UNCITRAL tribunals. He advises clients from throughout the world, particularly on dispute settlement matters. The other author is Luke Sabota. He's a 1999 graduate of the University of Chicago School of Law. He is now a partner with Three Crowns LLP, which is a law firm focusing entirely on international arbitration. His work at Three Crowns has included, among other things, work for Chevron and its international dispute with Ecuador. He's been spearheading a multi-billion-dollar contractual arbitration before the International Chamber of Commerce in New York, and has been actively involved in several ICSID cases as well. He has successfully argued cases in the U.S. appellate courts and briefed cases in the U.S. Supreme Court. The book is, I think, a very special one. Those of you who have studied public international law know that Article 38 of the ICJ statute gives us the sources of international law. And we usually focus on the first 2 of those: convention, treaties, and customary international law. And too often, that's where the discussion kind of stops. But a very important part of that provision says that the third important source of international law are general principles of law recognized by civilized nations. And that's what this book is about. The book has a foreword written by someone else who has visited us here at the University of Pittsburgh School of Law, Stephen Schwabel, who visited us when he was President Judge of the International Court of Justice in The Hague. Stephen Schwabel is now a leading arbitrator and did the foreword to the book, but and just to demonstrate how important I think this book is going to be, he referred to 2 people in that foreword. The first was Hirsch Lauterpacht. If anybody has studied public international law, you know the name Hirsch Lauterpacht. And he compared this book to Hirsch Lauterpacht's first publication, Private Law Sources and Analogies of International Law, that really launched his career. And then to Professor Ben Ching, who in 1953 wrote a book on general principles of international law. And this book really brings that book from 1953 up to date in the 21st century. And that, I think, is a huge contribution, a contribution that has been lacking for over half a century. And now we have it, and I'm really pleased that it's a part of the CILE Studies Series. So Charles and Luke, thank you so much for doing it as a part of the series. By the way, we do have flyers for anyone who wants to purchase the book at a discount from Oxford University Press available at the door on your way out. But I want to get out of the way, hand things over to Charles and Luke, and let them tell you about general principles of law.
Thank you, Professor Brand. It is a pleasure to be here at Pitt, where Chuck cut his international law teeth before going to the Max Planck Institute and beyond. And I understand that Chuck was a Panthers soccer phenom as an undergrad, and as you can see from the length of his hair, he has trouble letting go of his glory days. This is my first opportunity to meet Professor Brand, who first approved and then supported Chuck and I through the process of writing this manuscript. And to you, I am extremely grateful. He provided support for many more years than he expected to provide support because of the time it took to draft the manuscript, but we're very appreciative, and I think each of you should be appreciative, like Chuck, to have had the opportunity to study with Professor Brand. The CILE is a marquee institute, not only for Pittsburgh, but for the international community. So Chuck and I will be speaking today about facets of general principles of law and international due process. And I should warn you that these are basic and abecedarian legal concepts, such as the idea of finality, res judicata, or the right to an independent and impartial judiciary. General principles lack nuance, they lack depth, they are not sophisticated, they are not sexy. But I will submit to you that despite being extremely anodyne, general principles are absolutely essential to the international legal order. International relations are complex, and they are fluid, and they are often informed by conflicting understandings of state sovereignty. Concrete principles of international law that enjoy universal acceptance and even more adherence are in short supply. The two main sources of international law that Professor Brand alluded to, treaties, whether bilateral or multilateral, customary international law, which derives from state practice, these have their own limitations. Treaties typically are limited in scope and have somewhat ambiguous terms, and what level of state practice rises to the level of creating international customary law is often open to debates. There are thus gaps and significant lacunae to be filled, and it is in the many interstices of international law where general principles come to the fore. An early example comes from Roman times. Roman civil law only applied to Roman citizens. With the influx of peregrine, or non-Romans, into the capital, disputes arose for which there was a legal void. There was no positive law which could be applied to legal disputes between foreigners of different nationalities or between peregrini and Roman citizens. In such cases, the praetor had to decide largely on notions of equity. But as more and more people came into Rome from abroad, application of foreign legal principles became an everyday matter. And what the praetors learned was that certain basic ideas and principles were common to all of these foreign systems and to Roman law. In due course, these generally accepted principles across different domestic systems developed into a system of law, which was originally quite independent of the civil law and ultimately merged with it to create ius gentium. In disputes with a foreign element, praetors would thus apply these basic legal precepts, and this was a vast improvement on equity, which, when untethered to any definite metrics, is very difficult to call law at all. And the fact that these common principles were found in the legal systems of both disputants gave the process much greater legitimacy. Neither side could squawk about the use of fundamental legal principles found in their own domestic law. So this appreciation that comparative law studies can locate commonalities among different legal traditions has thus been a fixture in international law for some time. In the 2 millennia since, courts and arbitral tribunals have invariably called these traditional principles, principles generally accepted, well-known rules. A tribunal sitting in 1872 applied principles of universal jurisprudence, specifically that the burden of proof lies with the party proffering the argument, and justified this by saying that the legislation of all nations recognizes it. The Permanent Court of Arbitration in the Russian indemnity case of 1912 said that it was generally accepted that interest on a contract price forms part of compensatory relief when payment on that contract is delayed. The PCA wrote that this principle can be derived from all private legislation of the states forming the European concert as well as Roman law. And here in the United States, the U.S. Supreme Court over a century ago deemed res judicata a rule of fundamental and substantial justice. It is therefore quite natural that the preeminent jurists who were tasked with drafting the organic statute of the World Court, the Permanent Court of International Justice, after World War I, defined international law to include not only convention and custom between states, but also the general principles of law recognized by civilized nations within their municipal legal systems. The architects of the post-World War I system sought to supplement the loose bundle of customary state practices with a stable of basic principles capable of regulating the myriad issues arising from international intercourse. The general principles were seen as a necessary link between developed systems of municipal law and the inchoate system of international justice. Derived from legal principles found in all legal traditions, they provided a positive law footing upon which a system of international law justice could function, and a means to bind parties to basic juridical concepts to which no one could object, even if they had not been codified elsewhere. In drafting Article 38 of the PCIJ statute, the primary concern was with the situation of non-liquid, with the PCIJ being rendered powerless in cases where treaty and customary law did not directly speak to the issues presented. Baron Edouard de Camps proposed that in these situations, resort should be had to, quote, rules of international law as recognized by the legal conscience of civilized nations, which he understood to mean objective justice. The text was then revised by Lord Walter Phillimore, who understood the general principles of law recognized by civilized nations as those accepted by all nations in foro domestic. As Professor Cheng observed in his seminal 1953 book, the views of Phillimore and de Camps were in substance the same, and they accepted that there was a foundation in the laws of all domestic systems that could be elevated up to the international plane and treated as binding international law. General principles are quite obviously distinct from treaties, but they do have a conceptual similarity to customary international law. The primary difference is that general principles derive from the positive written laws promulgated within states. Custom, on the other hand, is typically moored in the practice among states and accepted by them as law. In the diverse family of nations with states in differing stages of economic, political, and social development, on-the-ground adherence to these fundamental precepts is bound to differ widely, especially when their application turns upon more abstract concepts such as whether a specific sovereign action is reasonable or abusive. As illustrated in decisions in award discussed in the book, violations of general principles are in fact legion. This unfortunate reality is what gives the general principles their continued salience today. Although it might seem that this non-adherence would call into question the recognition of a principle as general, just as the absence of de facto state practice would prevent recognition of that practice as customary international law, there is no paradox. When it comes to general principles, the focus is on what national law says, not what a particular government does. This is because the inclusion of a principle in the written laws of many nations and legal systems is itself a validation of that principle. Such laws are written ex ante without necessarily any thought of their eventual incorporation into international law or their possible invocation for or against the state and its citizens. Whereas customary international law derives its legitimacy from state usage, the general principles derive their legitimacy from state recognition. To borrow from John Rawls, all systems in the veil of ignorance recognize a priori the importance of pacta sunt servanda, that contracts will be observed, even if at a given moment a willful leader finds it expedient to ignore a state's obligation, say, to a foreign investor. General principles are understood to contain both substantive principles, which can provide a rule of decision for a particular controversy, as well as procedural requirements that are simple and basic enough to describe the judicial processes of civilized nations, what has been dubbed the international concept of due process. The requirement that no one may judge his own cause forms part of the procedural norms found in most judicial systems. And these general principles create a legal baseline for international law. They are meant not to define a rule of law, but rather the rule of law. What are now considered core principles of due process, principles that must, we view, obtain in all legal systems, trace back to Roman times yet again. The 12 tables codified Roman law in 450 BC as part of the transition to the Republic. Tables 1 and 2 articulated adjectival requirements such that the parties must have the right to state their cases by making brief statements in the presence of the judge between the rising of the sun and noon. And both of them being present, let them speak so that each party may hear. The judge was under an obligation to render his decision in the presence of the plaintiff and the defendant before the setting of the sun. And there was the right of anybody who was deprived of the evidence of a witness to call him with a loud voice in front of his house on 3 market days, the Roman equivalent of a subpoena, I guess. According to Livy, the 12 tables arose in part as a response to plebeian demands for written rules to avoid capricious and biased adjudication by patricians. Although the 12 tables were limited in scope, praetors and other magistrates would interpret them to fill ambiguities and lacunae, and then these decisions would be subsequently followed, allowing for the creation of an evolving body of law reflected in various edicts. In the common law tradition, reference to the Magna Carta is almost obligatory in any discussion of due process. The actual events surrounding the Great Charter's sealing in 1215 differ markedly from the near mythical gloss that surrounds it today. The Magna Carta was not particularly novel. The idea that the king was subject to law had for a long time been part of the orthodoxy of medieval constitutional thought, both in England and elsewhere. Nor was the Charter especially ambitious. The only institutional method for enforcement of it was set out in Clause 61. which called for a committee of 25 barons to enforce promises given by the king. But that clause, 61, was deleted the following year in the reissue of it by Regent William Marshall. The Magna Carta, moreover, was sealed by King John at Runnymede under the coercion and distress of an impending civil war. In only 3 months' time, King John had breached several of its provisions and persuaded Pope Innocent III to annul it, leading the barons who had temporarily suspended their rebellion to resume it. But unlike other charters from this time, the Magna Carta endured, and it constituted the first comprehensive statement in written form, formally promulgated to the whole English population, of the requirements of good governance and the limits upon the exercise of political power. These fundamental precepts of law continue to be applied today. With the growth of bilateral investment treaties and other international conventions promoting and protecting global commerce, private parties may now directly seek redress for violations of international law before institutions like ICSID, the International Center for the Settlement of Investment Disputes, which issued its first arbitral award in 1977. In this context, general principles can serve as substantive guarantees for the right of private parties vis-a-vis each other and even foreign states, be it by guiding the application of governing law or defining what is fair and equitable for foreign investments. Domestic courts have also been called upon to apply international law with greater frequency, such as when deciding whether to recognize a foreign judgment or arbitral award, or in applying cross-border legislation such as the U.S. Alien Tort Statute. The importance of international law today is increasing along with the number of venues applying it. Although general principles are, as I noted at the outset, basic and even rudimentary, they hold vital importance for the rule of law in international relations, and this is no mean task. Reliable application of even the most basic principles of due process remain elusive in scores of judicial systems around the country. Greater adherence to general principles, both by private parties and sovereign entities, would mark a significant improvement on the status quo, and with more tangible consequences for noncompliance, rising alongside with the advent of treaty-authorized arbitrations, the guarantee of general principles in international law becomes a real fixture and inures to the benefit of us all. Chuck?
I think you're going to move the microphone up here. I think it's probably just as easy. Thanks, Luke. Thanks, Professor Brand. It's a real honor to be standing in this room. I began my law school career in this room. I think first year contracts and con law was here. I met my wife in this room. She's sitting in the back now. I sat over here, and I think Becky sat over here. Is that right? But it's really great to be here. I took IBT with Professor Brand here. I took international law with Professor Lobel here, and I feel like I'm standing on the shoulders of giants, standing over here speaking to you all. And I also want to say I owe a debt of gratitude to Luke. I left law school here, and after clerking, joined Jones Day, and I was a young associate, and Luke was a young partner, and I spent most of my, the better part of several years working on a case with Luke. And this book is, I think you could probably find a lot of my old memos to Luke somewhere in this book, whether he knows it or not. So I owe a debt of gratitude that he was able to help me on this. So let me start with something a bit provocative, but also, I think, timely to set up this discussion. One point that I think was obscured a bit in the history that Luke talked about, the history of general principles, is this constant tension we have between nationalism and globalism. The pendulum is always swinging, and at this particular moment in time, we are living in an age where we hear a lot about physical barriers and walls taking the place of treaties and international discourse. And at least with respect to the law, the political rhetoric we're hearing is quite simplistic. Things that happen here should be decided by the laws that apply here, and foreigners should accept those laws, no matter how idiosyncratic or how awkward, and with all of their imperfections. This argument has been made really throughout history, and it really underlies choice of law, conflicts of law, private international law as a whole. And it may be pleasing on its face, especially when the alternative is applying a foreign law within our borders. But the world, as we'll see, is not so simplistic. It's not so binary. And I think what Luke and I are going to do now is go through two cases, two relatively recent cases to sort of illustrate exactly how general principles of law in international due process, why they're so important, and how they come to be applied. I'm going to talk about a recent investment arbitration dispute. Gold Reserve. Gold Reserve Incorporated is a Canadian mining company. It was founded in 1956. In 1992, it embarked on one of its biggest ventures. It acquired and began developing what is known as the Brices gold and copper deposit in southeastern Venezuela. The Brices deposit is one of the largest undeveloped gold and copper deposits in the world. For the next 15 years, Gold Reserve developed this area, invested in this area, built infrastructure, did feasibility studies. It really worked on developing the project that it needed and that it was investing in. And mining, as you can imagine, is highly regulated. The state was heavily involved, as is typical. The government expressly approved the progress as it went on for 15 years. It approved feasibility studies in 2003 and 2007. And later that year, it issued a permit saying you can start construction. You can start infrastructure construction. You can start building roads and building mines and getting things moving. Gold Reserve invested $200 million over 15 years. And after it received the permit, it invested another $100 million, hoping to get the mining off the ground. Then, a few months later, in October 2007, problems started. Then President Hugo Chavez took control of issuing all future authorizations, took charge of doing it himself, with the publicly stated purpose of recovering national interests from foreign companies. Within months, the Phase 1 permit, the construction permit, was revoked. Within a year, the entire concession was terminated. Gold Reserve's $300 million investment was gone. So what did they do? They could sue in Venezuelan courts. That's a tough row to hoe. So they sued Venezuela under a bilateral investment treaty, under Canada's bilateral investment treaty with Venezuela. Now this is a complex case. It resulted in a decision that I think numbers to about 400 pages. But I'm going to focus on one particular aspect of this decision that I think is interesting for a discussion of general principles. Let's look at the state's revocation of that construction permit, revocation of the Phase 1 permit, which halted and really precipitated the death of the investment. Why did the state do this? What did they say why they did it? They said it was because of the protection of the environment. There had been an environmental emergency decree in place in the concession area for a few years, thus necessitating greater protection in that area. And let's all be honest here. Who can deny that a sovereign state has the absolute right to preserve its own environment, to protect its local population from pollution, and protect local people who are living in the area? For all intents and purposes, under Venezuelan law, that was the end of it. The revocation settled the matter. There was no more mining were going to happen in this area. But now let's look a bit closer at Venezuela's rationale. And because the tribunal was an international body authorized by treaty to look into the matter, they could do this. They didn't have to look at just the revocation as the end of the matter. They could look into why this happened. And when the tribunal looked into why it happened, they found this. This state of environmental emergency had been in effect for almost a year when the Phase 1 construction permit was granted. And the permit was granted with a number of environmental conditions that had been subsequently satisfied. The emergency decree then lapsed almost a year before the revocation of the construction permit. And all through that period, the Venezuelan Ministry of Mines had been issuing certificates of compliance, telling Gold Reserve that what they were doing was okay, that they were complying with all regulations and requirements. Now, against this backdrop, should we blindly allow the local law decision to stand? The treaty allows the tribunal to scrutinize this situation under a very basic substantive command. And this is what Luke was talking about treaties. Treaties are not always nuanced. They don't have the detail to provide a rule of decision for any particular case. All the treaty said was that Venezuela had to treat Gold Reserve as a Canadian investor fairly and equitably. Fair and equitable treatment. That's not a lot of detail to go on, and it raises more questions than it answers. I mean, what does fair and equitable treatment mean? Can we discern anything justiciable from these three words? And I think more problematically, and this is where international law sometimes has a problem, if we try to do so just through some vague notion of equity and justice as our only authority, don't we risk exposing our own preconceived biases on what the result should be? We find ourselves falling somewhere in that pendulum between nationalism and globalism, between a state's right to regulate and investors' right for economic and legal security. So what did the tribunal do? How did it put flesh on the bones of fair and equitable treatment? It looked to the comparative analysis of many legal systems. It looked to general principles of law to determine what constitutes fair and equitable treatment. And when it did, it found a common principle of administrative law that is virtually everywhere. Whenever a state, in its role as a regulator, creates and promotes a legitimate expectation on behalf of a private party, those expectations deserve legal protection. The tribunal found this principle inherent in German law, French law, European Union law, American law, English law, Argentine law, and even, interestingly, it was a principle inherent in Venezuelan law as well. This is, as the tribunal held, a general principle of law for all civilized legal systems. So when Venezuela issued this construction permit, while this environmental emergency was in force, when it issued certificates of compliance for Gold Reserve, when it allowed the emergency decree to lapse while the construction was getting ready to move on, it created legitimate expectations on the part of Gold Reserve that all the environmental matters were settled, that they were all fixed, that they were all fine. Those expectations induced a $300 million investment. So when Venezuela undid this, when they undid their acts and their statements for pretextual reasons, they frustrated those expectations. They ran afoul of this general principle of law, and they violated their treaty obligations of providing fair and equitable treatment. If there's any debate about this, months after the revocation, the Venezuelan Minister of Mines was quoted in the paper that the permit was being revoked in order to take back what is ours from the foreign companies. In a situation like this case, we can learn something. While we have these nationalistic tendencies that local law should govern local issues, especially these sensitive local issues like the environment, local populations, that is important. But justice isn't always found in that situation. Justice, however you define it. And Luke's going to talk more about this in a minute. But at the same time, international law, when the dispute percolates up to the international level, international law can provide a reserved store of principles through which we can find justice. But supplanting local law with international law is delicate business. And it really brings out a lot of the backlash you see to international arbitration, especially treaty arbitration today. But here's what I like about what the tribunal did in Gold Reserve, and I think here's why general principles are so important. It grounded its decision on what is fair and equitable treatment not in its own thoughts or biases of what justice required, not in some balancing of the equities. It grounded the decision in the confluence of positive laws from around the world. This, I think, is the most defensible way to figure out what fair and equitable means as a matter of municipal law everywhere. So it's less of an imposition on the Venezuelan legal system. And in fact, you're applying a principle of Venezuelan law. For sure, to override one of their decisions and override a rule, but the principle remains true. And I think that's what we can learn from the gold reserve decision, is that tribunals finding a way to provide flesh on the bones of these very simple treaty obligations can and should look to general principles of municipal law to do that. Now I'm going to turn it back over to Luke to go over another case study here that I think is interesting. But the point of this segue here is this doesn't just happen in international tribunals. It occurs in national courts as well. And he'll talk right about that now.
So before I turn to the case, I want to just read you a quote from Rufus Choate on the occasion of Massachusetts Constitutional Convention in 1853. "The best judge shall know nothing about the parties, everything about the case. He shall do everything for justice, nothing for himself, nothing for his friend, nothing for his patron, nothing for his sovereign. If on one side is the executive power and the legislature and the people, sources of his honor, the givers of his daily bread, and on the other side, an individual nameless and odious, his eye is to see neither, great nor small, attending only to the trepidation of his balance, where there is no judge. Impartial and independent justice has long been a fundamental tenet of international due process. This includes, as emphasized by Choate, judicial partiality towards the sovereign. As he explained, when there is judicial capture by the political branches, the judge becomes the tool of the hand that made him and can unmake him. And even with the advent of Republican forms of government today, the companion principles of impartiality and independence are far too often honored in the breach. Today, nearly every nation provides in its written law for an independent judiciary, which renders this a general principle of law. That consensus has been mirrored on the international plane, with intergovernmental and non-governmental organizations expressly recognizing judicial impartiality and independence as an integral basic human right and the right of an access to justice. But despite these florid de jure pronouncements, undue executive and legislative interference with the judicial function continues to be a de facto scourge. In your materials, you find a map, which is the 2016 Corruption Perceptions Index published by Transparency International. It measures how clean or corrupt public institutions are in 176 countries based upon the perceptions of those who interact with those institutions. Yellow is good, red bad. And as you can see, the world is largely burnt orange. Specifically, only 54 of 176 countries, that's less than a third, score 50 or above on a 100-point scale for corruption. And this map in front of you is merely indicative. The same bleak picture is painted by various NGOs who have studied judicial systems around the globe, including Freedom House, the World Justice Project, and the Heritage Foundation. One other statistic from the 2015 World Bank Governance Indicator for Rule of Law. It found that only 90 of 215 countries enjoyed a positive score with respect to the reliable application of law. It is no exaggeration, as Jan Paulsen has written, to say that it is an error to think that justice is normal. It may be more realistic to think and act on the assumption that justice is a surprising anomaly. Where you have systematic failings in the judiciary, international courts have found a denial of justice on the international plane, and domestic courts will review a judicial system in determining whether or not to recognize a judgment issued abroad here in the United States. In doing so, U.S. courts apply a universal rather than a parochial notion of due process, and they have denied recognition to foreign judgments where judges are, quote, subject to continuing scrutiny and threat of sanction by the political branches, where judges serve at the will of leaders of political factions, or where there is a close interwovenness of the parties and the machinery of justice. So the example which is in your materials comes from a Moroccan judgment arising out of the Talcent oil project. This project held such promise that the King of Morocco personally announced the discovery of copious and high-quality oil in a nationally televised speech, which caused the Moroccan stock market on a single day to jump 5%. When the predicted oil was not there, the project disintegrated, and the king's credibility personally suffered. Two of the project's investors brought an action in Moroccan courts against a third investor, John Paul de Joria. You may not know the name, but I am almost certain that some of you have sipped his Patron tequila or washed your hair with his Paul Mitchell shampoo. De Joria was accused by his other co-investors of fraud and mismanagement. The King of Morocco had made similar accusations against de Joria, such that if the suit against him failed, the king could, quote, and this is now a district court judge writing, appear foolish if not downright dishonest for having promised so much oil during his now infamous speech. A Moroccan court ultimately entered a judgment against de Joria of $122.9 million. The two co-investors sought to enforce it against de Joria's assets here in the United States. The U.S. district judge hearing the case explained that where there is evidence that a country's judiciary is dominated by the political branches of government or by an opposing litigant, or where a party cannot obtain counsel, secure documents, or secure a fair appeal, recognition of a foreign judgment may not be appropriate. These are core statements of general principle. While noting that serious strides had been made in Morocco to establish a societal framework founded upon the rule of law, the district court cited a 66-page report by the U.S. government, which concluded that the judicial system in Morocco is, quote, permeable to political influence, because the mechanism through which judges are appointed, promoted, sanctioned, and dismissed leaves them vulnerable to political retribution. The court found it significant that the King of Morocco presides over the body that appoints, disciplines, and promotes judges, and that roughly 1,000 Moroccan judges, armed with petitions signed by another 2/3 of all judges, held a sit-in protest demanding structural reforms to guarantee their independence from the king. The court also recited an admission by Morocco's foreign minister that this country suffered from what he called phone call justice, a call from the Ministry of Justice to a judge as to how to rule in a particular case. And the foreign minister concluded that judicial independence is not the reality today. All of this raised in the U.S. District Court's mind serious questions about whether any party that finds itself involved in a dispute with the Moroccan royal family, be it economic or political, could ever receive a fair trial. In light of the king's reputational interest in having the lawsuit against de Joria succeed, the court refused to recognize that judgment. He wrote, whether or not the king or some other official picked up the phone and ordered the judge to find against de jure is, in some sense, beside the point. Judges are not stupid, people oblivious to outside pressures. Moroccan judges are keenly aware that their livelihoods, present and future, depend on remaining in the good graces of the king and the royal family. And for this reason, he refused to recognize the judgment in a concrete application of general principles today.
So I'm just going to try to sum up what we've talked about here today. In the past half hour, we've talked from principles in ancient Rome, cases in Morocco and Venezuela, and if we had more time, we could talk about cases arising out of all these places in between. The point, I think, of the book and the point of today's lecture is really this. When you really think about it, even at the international level, we stand atop centuries of legal principles, not rules. Those come and go with passing administrations and passing politics, but centuries of legal principles developed precisely to dispense fundamental notions of justice. And that this development be allowed to continue and be supported, I think, is vitally important. Why? Because even in today's heated political rhetoric on globalism, it is naive to think that international trade flows are going to all of a sudden stop. As long as there is a gulf in the availability of capital and know-how and natural resources around the world, there are going to be investors like Gold Reserve going to places like Venezuela. And they're going to be pressing capitalistic rights and capitalistic interests that are going to come into tension with sovereign right to regulate. And there's going to be judgments that are rendered in one state need to be enforced somewhere else, that have to cross borders and have to be assessed on what is fair and what is proper and what is justice. So how do we alleviate these tensions, I think is important. And we can't just blindly defer to local law. I mean, the map that Luke talked about in your materials is Exhibit A on why we can't just do that. One of Luke and I's mentors, Tim Cullen, who's also a partner at Jones Day and once the head of our global disputes practice, said, when you're advising a client on what courts they'd like to be in, what courts they might want to put their disputes in, that list is really about a half dozen. Maybe 10, but there's a lot of hand-wringing between 6 and 10. And that's just the reality of it. So we can't just blindly defer to local law to alleviate this tension. And this is why I think international law is more important than ever. But I do think it requires us as thinkers, as students of this, to rethink what international law means. And we learn in law school what public international law is really comprised of treaties and custom and state-to-state interactions and state-to-state treaties. But the reality today is a bit different. Private parties, corporations, individual investors are increasingly being subject, are increasingly looking to use international law to press treaty rights against other sovereign states. And national courts are required to apply international law more and more in enforcing foreign judgments, in ATS claims, and so forth. The problem we have is international law, as we know it, is fairly nascent. It's relatively tailored through centuries just to deal with state-to-state disputes. Treaties say things like fair and equitable treatment that rarely provide enough detail to really be a rule of decision in a particular and often incredibly complex case. So this is where general principles, we think, comes in. Because they're derived from municipal law, because they're derived from the law that regulates people, private persons, corporations, they're uniquely tailored to these sorts of disputes. They're uniquely tailored to provide a little bit more complexity for cases that arise. But because they're sufficiently international because they're based on the confluence of all laws. And they're relatively stable too. One administration going into power in one place that retrenches a bit on globalism doesn't really change what is a general principle very easily. It remains relatively stable. And with these sort of dual characteristics, I think our inclinations towards nationalism and globalism are a bit more imbalanced by using general principles to deal with these sort of cases. And it's no easy task, but hopefully, our book and those before it and those that follow it on general principles will start to proliferate more, and tribunals and courts will start to use them more to dispense international justice in these very complex cases that are not by any sign going away. So that's it. That's our book. And I'd like to open it up to anyone that has any questions about general principles, international law in general, the practice of international arbitration. Luke and I could probably talk a little bit about, even if it gets beyond the scope of the actual book, I would be happy to speak about. So go ahead. Yes?
Well, I was intrigued by your handout here. And the first thing I noticed is the U.S. isn't as high as one might hope. It's like 19 points or so below the top.
Yep.
And I wondered if there was any, I don't perhaps naively think of U.S. courts as particularly corrupt, but nevertheless wondered if you had an explanation. And also I was curious if any of the courts in jurisdictions above us have failed to recognize U.S. judgments on the basis of concern.
Can I grab that? Look, you can add into this as well. It is surprising that the U.S. is so low. One thing I would say on when I said you don't want to send one of your clients in a complex case to one of more than 6 courts is not always just because of corruption. A lot of it has to do with ability. The courts in New Zealand are hunky-dory. They're second. But if you want to send a complex construction dispute to the courts in Auckland, maybe not something you want to do. So there are a lot of other factors that go into it. As to why the U.S. is lower, I can't really say for sure, although there has been a lot recently, a lot of things written about the way we appoint state judges, the way election of judges is not always the best way to do things, and you see that in a lot of other countries around the world where the election of judges can lead to political capture of the judiciary. And if you ask me, that is one of the things that probably leads to the U.S. being lower than usual. Luke, do you have anything to add on this? Yeah, I think that is largely right. And unfortunately, I think the Commonwealth of Pennsylvania is one of those states that elects judges. And if you were to ask me, that's highly problematic. And if you want to see how it's highly problematic, you can go to a place like Ecuador, where the political capture of the judiciary can be a real problem, and that's part of it. Yeah.
Hey, Robert, would you mind coming up here so we can pick you up on the mic? Sure. I'm loud, but.
Trying to scream the microphone.
All right, so I want to make sure I ask this right because I feel like it's more complicated than it should be. Luke, you said that in customary international law, it is created through practice, whereas general principles are created through recognition. And then in the Venezuela case you pointed to, you emphasized that the general principle also existed in Venezuela. In a hypothetical situation where that didn't exist, what would be the consequence?
My view of this is, and Luke, please add into this, one state can't veto the creation of a general principle. I mean, this isn't an all or nothing thing. You don't have to survey 176 countries to make sure the principle exists in every one. That would defeat the purpose. Because the purpose of the general principle is to create some sort of corrective mechanism, and that one state can't veto the creation of that. Now, that's the one beauty of these principles, though, is they're often phrased so generally that it's often difficult to find dispute in a lot of places. The principle of res judicata, that a final judgment should be respected. That's a principle everywhere. That being said, you probably don't have to look very far to find some countries that don't always apply it correctly. That'll reopen decisions sort of at the political will. Pacta sunt servanda, contracts should be enforced. Can we all agree that every civilized jurisdiction has that as a general principle, even though in practice it doesn't always work that way? But that's the beauty of the general principles. So if that principle had not adhered in Venezuelan law, it's still a general principle. It's still a general principle of the protection of legitimate expectations whenever the state gives rise to those expectations. So, and I think that's the beauty of it. And this also goes to why general principles have been so difficult. And we didn't talk about this here, but we talk about this in our book. Why they're so difficult to really develop and pinpoint is courts have not always gone about creating them as scholarly as one would like. The International Court of Justice has applied general principles over and over, and they usually just say it. Pacta sunt servanda, it's a general principle of law. They don't go through and footnote laws of every single country to do a comparative analysis of whether it exists. I think it would help if arbitrators and judges would have a little bit more academic rigor in the comparative work, but it's certainly not necessary, especially when you're applying sort of baseline principles that we all agree on. Luke, anything to add? Yeah. Yes.
In your experience, do you find that arbitral institutions are more likely to kind of give deference to these general principles over national courts, or is there not much of a difference there?
Yes, very, very easily. I would say yes. If you have a complex international law case and you're making a decision as a general counsel of whether you want it decided by a guy named Jan sitting in Switzerland, or a judge on the Southern District of New York Court who's just finished sentencing a few drug offenders and deciding habeas petitions, you probably went to tribunal looking at something like this. That is one of the benefits of arbitration. And the people who are arbitrators are typically more schooled in this sort of thing. But one hopes that providing international law in a more digestible form for judges, I think, is something that we should all in the field try to do better, so that it does get applied more in courts and not just left to the academics sitting in an ivory tower of arbitration. So yes, I think the answer to your question is absolutely yes. Yeah.
Hisham, while you're coming down, I'm going to ask a question, and then we'll give you the microphone. When we look at the three sources of public international law in Article 38 of the ICJ statute, each of them requires in some way an indication of consent by the parties, and consent is fundamental. With treaties, it's easy to figure out where the consent comes from. With customary international law, the consent comes from some indication that the state not only acts in a certain way, but they act that way because they consider themselves bound. Opinio juris. In general principles, I mean, you could say it's because of recognition, it's because they've included it in their own laws. But as with customary international law, at some point you have to determine how far the dial has to go to indicate it. In general principles, maybe both of you can comment on this, what's the point on the dial that we have to reach before someone can say it is a general principle?
Luke, do you want to take this one?
The reality is no one knows, because no jurist has really attempted to legitimize a invocation of general principles. The historical reality is that general principles are just announced based on intuition and fiat. And a number of commentators have argued, well, that's fine for those very low-level principles that brook no dissent. But I think that I personally could imagine a number of principles being deemed general principles if you actually sat and did the comparative work. And the language of the statute is quite unfortunate. It refers to general principles of civilized nations, which is an anachronistic and now offensive term. And I think, though, that most true comparative scholars that we've read think that you can systematically go about today with relative ease in determining at least what civil law, common law, Sharia law would say on a particular issue. And you don't need to have a complete unanimity, but you've got enough that you're not going to give credence to the outliers and say that there's something fundamental here. But the process is more aspirational than reality.
I almost wish Professor Curran was here to talk about comparative law, because this is really a confluence of comparative law and public international law in a really interesting way. It really makes comparative law practical in a real form, because the easier way to do this is not look at 170 different countries, but to look at families of law, right? You can common law, civil law, Sharia law. Indian law, I think, is one of these families of law, makes it a lot easier.
Thank you very much for your interesting talk, and congratulations on your new book. My question is about the space that a state has to take action against its international commitments in case of, let's say, a crisis or anything that serves its internal interests. Can a state go against its international commitments to serve its internal interests? And in this regard, specifically the Argentina, when Argentina had its crisis, and we saw all these investors sue Argentina in international forums. But on the other hand, Argentina was having a crisis, and all the measures that it took was to serve these crises. So it went against its international commitments for its internal interests. So what is the amount, what does general principles of international law talk about that?
I mean, there's a lot of decisions on the state of necessity, and this is what I think the Semper decision is one of the key decisions on this point of what a state can do when it has to act. But I think the important point where general principles come in, and this is a bit of analogous to the gold reserve case. It's a bit analogous to the gold reserve case that sometimes you have to look at the rationale. I think the general principle behind allowing this is a state can't take advantage of its own wrong. So the way the defense of necessity in the Semper case is articulated is that if the state had a hand in creating the state of emergency, well, then it can't rely on its own wrong to say that this state of emergency should get us out of our international commitments. So I think that is one of the factors, general principle factors, that go into assessing what a state does and whether it's allowed to do that. That's.
Yeah, I mean, the general principles that would speak to an invocation of a necessity defense, I think, would be more along the lines of proportionality. And there, the Argentina cases are really a hot mess of differing resolutions in terms of whether arbitral tribunals or annulment committees deem the defense acceptable, and so the law is quite murky. But I think what has to be true is that the mere existence of a crisis doesn't absolve the state of its international obligations. In some ways, necessity is part of international law, and it's effectively saying you can derogate from certain commitments at certain points of time. But the principle of proportionality, which is really where a lot of investor-state cases hinge now, that's where you would say, did you have any other alternative to this situation but to take action against these particular class of companies or investors, and what were the other alternative means available to you? And I think that's where general principles would hold sway.
And I think you're going to see a lot of this coming up soon. I mean, I've seen a lot of reports of cases being filed against Libya for the Arab Spring uprisings. A lot of companies who suffered losses there. And that's an interesting thing about investment arbitration. It usually follows 5 years after political crises. That's just the reality of it. And now you're seeing a lot of Libya cases pop up, and this is going to be hotly arbitrated, litigated. Is what sort of legitimate expectations did a company have in Libya if you were investing in the spring of 2011? How does that change if you invested 10 years prior? And so if you're looking for jurisprudence on that, I think probably wait 2 years and you'll have a lot more.
I think I'm pretty loud. Thank you. So I have, I think maybe a two-part question. So one thing, it seems like you're trying to raise the sort of primacy of general principles of law. And so my understanding of general principles is that it's a gap filler that courts use when, treaty law is silent or customary law is silent. And so if we're raising the primacy of general principles of law, I guess I'm wondering what the dangers are with that, particularly as Ron was mentioning, we don't really have external checks to sort of verify, or at least courts aren't doing this in a rigorous way to verify what the content of general principles of law are, right? So right now, we're talking about res judicata and other principles, procedural principles that are relatively non-controversial, but you could imagine a case where a court or tribunal says, oh, this is general principles of law, and we don't really have anything to sort of check that because we don't have, either state practice through customary international law to fall back on, or treaty law necessarily to fall back on. And I guess I'm imagining a scenario where a court looks at its own municipal law and says, well, surely this must be a general principle elsewhere. It's part of our law, so other nations must recognize it as such. Our law is superior, and so it's a general principle, without doing the comparative law analysis, right? And so what are the, I guess, dangers, right, of raising the sort of primacy of general principles of law, and how do you see sort of fleshing out the content or the contours of it so that it's not just anything that a judge says or an arbitrator says?
But I guess the first comment is you're absolutely right. It really is, it tends to be a gap filler. There are some concession agreements that dictate that the case will be decided by general principles, in which case you're starting with that. Alternatively, you'll have arbitral clauses that say this law will be governed by the laws of Libya except to the extent that they conflict with general principles of law, and then the arbitrators have to decide how they relate. In terms of risks, I guess I would say that if you have ipse dixit declarations of novel applications of general principles, you would have the risk of annulment, as you did in the Klockner decision, where a tribunal purported to apply general principles but didn't adequately explain its reasoning, and the decision was vacated. So there's some check at the back end. In the vast majority of cases that don't face serious appellate review or annulment, I think you'll have effectively an incremental system where you could have a particular case that articulates a general principle, does the comparative law analysis, and tries to distill the legal principle to its essence. And those type of cases you would hope would shine like a beacon and then continue to build precedent. But it would most certainly be an incremental process. And there could be those that simply are not persuasive or that go too far in trying to stretch a international consensus, and you would anticipate that those would flicker and face a near instantaneous death. But I don't think that there's any real risk of lack of legitimacy as long as the work is being done and the homework is being shown.
I think that was a bit of the challenge that we put forth in the book to international law scholars, and thus to arbitrators as well, is start flattening the paths through the forest on what is a general principle and what is not. And when the homework is done, I think it has a lot more legitimacy to what these general principles are.
Perhaps the answer to the question is the general principles are the ones that have been defined in the book. We've reached the end of our time. I want to say thank you to Chuck and Luke, both for writing the book, and for writing it second for writing it as part of the CILE study series, and third for being here to share your insights with us. It's been wonderful to have you here. Thank you.
Thanks, Professor.
there are forms that you can get